I don't want to reinvent the wheel, but I do want to point out again, Rule 1313 is very specific. And in this particular case, my client was suspended for 200 hours. In the letter of suspension dated October 13, 2021, as it relates to Mr. Turner, one need look no further than the third full paragraph on page 2 of the letter suspending my client for 200 hours. Where it reads, on June 30th, 2021, Captain Brad Cook informed Major Jason Turner about the association of the prior Louisiana Fusion Center email and your secondary employment application. Major Turner requested Captain Cook send him your email containing the application. Captain Cook further explained he had a conversation with your supervisor, Sergeant Flouse. Captain Cook and Sergeant Flouse had seen the social media post on Facebook and realized the association between you and Elijah Steele. Captain Cook stated he contacted Major Turner for direction on handling the secondary employment application. He stated at the request of Major Turner, he had Ms. Woodall email the application to Major Turner. Captain Cook stated Major Turner instructed him to request additional information relating to the form and request a copy of the literature from you. Captain Cook sent you an email requesting a copy of the book. Captain Cook said he did not receive a response from you. That is not the only place in the 200-hour suspension letter of October 13, 2021 that we're here about, wherein Mr. Turner is specifically referenced and intimately involved. Again, in this
I don't anticipate we're going to be hearing arguments about
well, again, this was a subpoena that was issued. I'm unaware of any communications before the April 14th hearing date. The subpoena was both issued and served to Major Turner. We identified in our request for subpoena the reasons for it, including on Mr. Turner, the fact that there are emails that were exchanged, and the addition on his is requesting authentication of emails between he and Mr. Cavalier's supervisors, of which Major Turner was one as well. In this particular instance, again, this is a subpoena validly issued. It was served. Mr. Turner simply did not show up. He is intimately involved in the 200-hour suspension levied against Mr. Cavalier, which is what we're ultimately here about, at least on level 1. Level 2 is the termination. And we ask that he be held in contempt. Thank you.
Mr. Bourne, is there any dispute that Mr. Turner received the email in his email account?
Yes, he did receive an email. He did not receive a subpoena, but he did receive notice that the hearing was set for that day.
And there's no dispute that that was normally the way in which individuals who were within the police service would receive notice of hearing and be required to attend.
I don't dispute that now that I have read the rules, nor does Mr. Turner now dispute that, as he has read the rules and been advised that.
Nor do we dispute that those rules were available in public knowledge within the state police. Okay. All right. Go ahead.
So I can just tell you what Mr. Turner's position is, which I think might shorten this commission's work on this issue today. Mr. Turner retired on April the 10th with 25 years of service. A couple of weeks before his retirement, he received an email from the state police concerning an April the 14th hearing. He believed that he would be retired prior to the hearing, and it was his belief that any orders from Colonel Davis or his designee became void upon his retirement, and he was an LSP employee but now a private citizen, and a subpoena would be required. He acknowledges that he was totally mistaken in that. He acknowledges that the notice rules exist, and he believes that he should have appeared on the date of this hearing. He maintains that the reason he did not appear was because of error, not because of contempt. And he has asked me specifically to note, and I'll quote from him, that he has served previously a 6-year term on this commission as an elected member. He has the utmost respect for the commission and the important role the commission plays regarding disciplinary cases. He maintains that he never intended to be disrespectful to the commission, and he apologizes for that perception. So basically, this is not a dispute about whether he should have appeared or not. He recognizes that he was required to appear, and he was mistaken in his choice not to. He's since consulted with a lawyer who has reconfirmed his acknowledgement that he should have appeared. And so to me, there's two issues that I would suggest. One is, what is the proper punishment? This will come as a surprise to those of you who have not practiced law with me, but I have occasionally been late to court. And when that has happened, I have apologized to the court for being late because my garage door didn't open, or I got tied up in traffic, or whatever it is. And I believe that the punishment that I have received for that was tempered because I acknowledged my mistake and showed no disrespect, as opposed to if I were to have said, well, Judge, I didn't come here because I think that you conduct a sloppy court and you never appear on time anyway. Which would be I'm not saying that that wouldn't have been a truthful response, but I am saying that I know better than to say that. The second thing that I recognize that there is the prospect of a fine, and that it can be in any amount, and I think that the amount of the punishment should be tempered by the intention of the party who violated the rule. The second thing that I would say is I was not aware until this morning the nature of the information that was requested from Jason Turner. I read that document this morning that Mr. Unglesby showed to me. Mr. Turner and I are both free and have no conflict with the July 28th setting for this.
And you agree that no additional subpoena or notice will be required?
He will accept a subpoena. I believe that some of the matters are simply a matter of identifying documents, which I believe can be done by stipulation. Now that I know what the issue is, if we can't, then we can deal with that at the time of the hearing. And if I feel, after reviewing the facts more, that it's necessary to file a motion to quash or appropriate, I will. But we will accept notice today for the July the 28th. And I know that Mr. Turner would like to simply personally apologize to the commission for not showing up. Yes.
Yes, sir. Like Mr. Bourne said, I have the utmost respect, having done the job. I think it was 2015 when I left office. I respect what y'all do and the important process that y'all play in the oversight of the state police. And I apologize for the perception that my not showing up on April 14th presents.
Thanks. Any questions? Any response?
Yes. My client has been terminated.
Brief response.
Brief. He's been terminated from the state police. He currently works as a long-haul trucker. For him to have appeared at the April 14th date with the full expectation that the witnesses would appear and we would have handled this matter meant that he canceled loads, and not just loads for that week, but loads for next week. We're here again today for this hearing, in which my client advised me he also had to cancel loads. He has cleared out his load schedule for the 28th of July to come back. Why are we coming back? Because these people didn't appear in the first place. He's not only having to cancel loads to support his family, but he's also got to pay an attorney, although I'm being kind to him. But I mean, come on. He had to prepare for the hearing on April 14th. He's got to be here. He's doing a long-haul trucking job, which is extraordinarily physically taxing. He takes all that time off, cancels loads, comes here, and they don't bother to show. I would ask that you would consider that. I understand apologies are wonderful. Apologies have a great purpose, but saying I'm sorry doesn't wipe out what you did. And I would ask that you would consider that in enforcing your rights and obligations under 1317. Thank you.
I have nothing to add. If any members have a question for me or Mr. Turner.
Doesn't appear. Thank you. You do wait around because we're going to hear the motion related to the state police, and then we'll go into executive session and come back out.
I should also say that the letter from Mr. Turner said, please consider this as a motion to quash. May I say that that motion to quash is at this time withdrawn, and if we feel as though one is necessary, we'll file it at the appropriate time before the 28th.
File it with sufficient, is there a deadline?
Well,
That was the suggestion I was gonna make, if you wanted to have motions to quash submitted prior to, so that they could be heard at the June meeting and resolved before the July 28th, that's a possibility.
We'd entertain a motion to set that as a deadline.
Second.
So, motion, so it's been moved and seconded that the motion to file, the deadline to file motions to quash will be,
Didn't we already have the deadline for them? I mean,
Okay,
that's,
this is very confusing. After our last meeting, we had deadlines for those who were present, we gave to file motions to quash. The present company was not present, so that, and that, those deadlines have come and gone. So this would, if what you're talking about would be a new set of deadlines for a new hearing on a motion to quash at the June meeting.
yes.
So, I don't have a June date right here. June the 9th is the meeting. And so, we could have the motions to quash, let me pull up my calendar so we can.
but is that only to Mr. Turner, because everybody else had a deadline? That's my confusion.
Well, Mr. Reeves did not have a deadline either.
He filed a motion to quash, he sure did.
So,
We did have I believe you did have a deadline.
Okay.
I had presented him with the same order.
So this relates to Mr. Turner.
Right, so Mr. Turner, so June 9th would be the meeting, so if we could have any motions to quash filed by May the 26th and any opposition by June the 2nd.
So can you accept that as part of your motion?
Yes.
Okay. Any discussion? All in favor?
Aye.
Any opposed? Ayes have it. So now they,
May the 26th is our deadline for filing, and June the 9th would be a hearing on it. We had to have it.
Correct.
Okay, so that and July 20th.
Now, are you saying this does not apply to Mr. Oglesby and his client?
well, he's filed his motion to quash already, right? What we're saying did not apply was the deadline to file. We'll hear it. We'll hear it on the night.
Okay, so you'll, yeah. Your motion that you already filed will be heard on June the 9th.
Oh, all right, okay. The
And-
motion that's before the court for today is on June the 9th. And if I have a motion to quash for the July 28th
8.
hearing, I should file it by May the 26th? Is that what
If
they're-
there-
Well, but you've already filed your motion to quash. Do you anticipate needing a supplement based on the additional information you obtained today?
Yes, yes.
I think what's,
And at least I gotta go listen to it, and yes.
I think one of the things that might be confusing to you is that the last meeting in April was the original hearing date. So that hearing date was changed to July the 28th. And the motion to quash that you previously filed still has to do with the same matter, the same hearing, and the same subpoena. And if you want to amend your motion to quash, it would have to be done by May the 26th, so that it's
Right,
then
but it is submitted,
part
I
of.
just accept it orally.
Well,
Okay, I got it.
It's for the subpoena that we agreed would be enforced relative to the July 28th.
Yes,
Me.
yes, certainly. And so, please tell me again my
So
deadline.
May the 26th is the deadline if you were going to amend the motion to quash,
Okay.
to add anything more. And the argument on it will be June 9th at the meeting that's regularly
Oh,
scheduled here.
and so then we come back June 9th,
Yes.
and I'm gonna ask one more question. On that here, on June 9th, is Colonel Reeves required to be here, or is that just me?
I don't think so. I mean, no.
No, I didn't.
It's just
That's gonna be
argument
your
on the
call,
motion.
but yeah, I mean, You make that decision, but yeah, you are required to be here to argue your motion. If you believe you need Colonel Reeves, then you have him here. He's not under the subpoena power. He has not been subpoenaed or being told to come by this commission.
But yeah, definitely July 28th.
Definitely July 28th.
That's the hearing.
All right, got it, Tony. Thank you.
Well,
Yeah, unless your motion is approved by the commission, then he has to have it. Correct?
right.
His motion to quash,
Right.
and we hear it on the 9th, then he doesn't have to come
Yeah.
to the July 28th hearing. That's why you're coming on the 9th, to argue.
I understand. Okay, thank you.
Good deal.